Item number 1.
Lord, I'm appearing for the petition, Your Lordship. This matter, the petitioner do not want to proceed with the
I'm
matter.
appearing for the respondent corporation CSTC. Your
Yes.
Lordship. I'm appearing for the respondent corporation CSTC. Your Lordship. I'm led by Mr. N.C. Bihani.
You are led by?
Mr. N.C. Bihani.
Where is Mr. Bihani?
My lord, Mr. Bihani.
Notice. Notice.
You are a panel advocate of CSTC?
Yes, Your Lordship.
Panel advocate?
Yes, Your Lordship. I have my wakalatnama, Your Lordship. I'll file in the course of the day.
Have you filed your wakalatnama?
No, my Lordship. I'll file in the course of the day, Your
Why?
Lordship.
This is a writ petition of 2020.
My Lord, this is a changed brief, Your Lordship.
So why you have not filed your wakalatnama? Then how you can appear?
My Lord, I have the wakalatnama with me. I will file by the course of
But
the day.
unless until that is filed, you cannot enter appearance. Have you taken instruction regarding withdrawal of this writ petition?
Yes, Your Lordship. I have a talk with the law superintendent of the corporation, Your Lordship.
Ask Mr. Bihani, tell Mr. Bihani to come. Pass over. Tell Mr. Bihani court is calling him.
Yes, Your Lordship.
Item number 2.
Madam, for the petitioner.
এটা রেখে দাও তো সব শুদ্ধ ওর চিঠিপত্রগুলো আছে
Petitioner do not want to proceed with this matter. Madam, this is my written instruction.
I'm for the respondent railway authorities.
which authority respond
Railway.
railways you don't have any objection issue matter is accommodated in the list under the heading to be mentioned, quote unquote, on being mentioned by the learned advocate representing the petitioner. Next paragraph. Learned advocate submits today that petitioner does not want to proceed with the matter, and in support of same, a letter dated 18 November 2025, which the learned advocate has received from the petitioner, is placed before this court and taken on record. And is taken on record. Next paragraph. Railway Authority, Eastern Railway.
Mr. My Lord, this is NFL. I have been directed to appear in this matter by Justice Ra. It is NF Railway. NF Railway too.
Not Frontier Rail.
The respondents are you are representing all the respondents. Respondents are represented by learned advocate. Next paragraph. In view of submission, submission made on behalf of the petitioner, writ petition stands dismissed on the ground of non-prosecution. Stop. Interim order, if any, stands vacated. Next paragraph. Parties to act on the server copy of this order duly downloaded from the office. Next. Item number 3.
I have appeared for the petitioner, my lord. Virtually, the advocates are going to.
Virtually, who is appearing?
My lord from Delhi.
Lordship, I'm appearing on behalf of the petitioner in this matter.
You are appearing for whom?
Petitioner.
But who is appearing for the respondent?
I already sent through hand delivery, my lord, tomorrow as per.
But there is a difficulty, madam.
My lord, kindly.
In the presentation form, you have stated that matter is to be moved on 28 November. In the here this court, you are appearing for the respondent.
Respondents, my lord. So item number 3, my lord.
Yes, yes.
3.
Yes.
I'm appearing for the respondents, my lord.
Yes. Yes.
Lordship, just confirming if I'm audible.
Yes.
Thank you. So, Lordship, this writ petition is brought before this court because the petitioner actually is a present employee of Coal India of the respondent, and there was a computer-based examination for departmental promotions that was to happen. The exam is scheduled on 29th of November. and the petitioner is eligible for this particular examination according to the notification that was brought in February 2025, and accordingly there was also a requirement that the CBT would be given by the candidates and the admit card has to be provided. However, the admit card was not provided to the petitioner on the grounds.
Will provide admit card.
No, Lordship, we are seeking a direction from this court to
I am asking you who will provide admit card.
Coal India, sir, the respondent.
This is an internal examination for promotion or a fresh recruitment.
Internal examination.
So petitioner is working in which post?
So right now he is in the position of grade 1 junior scientist assistant.
Grade 1.
Junior scientist assistant.
And the promotion, he is claiming promotion to which post?
The post has not particularly been specified, but the cadre is an executive cadre, sir. Right now, he's in a non-executive cadre, and through this promotion, he would be getting the benefits of being in an executive one, which is E2 grade.
You are representing Coal India?
All the four respondents, my lord.
Lordship, the position here is the position that they have taken.
Where
here
is the promotional notification? Where is the notification relating to promotion?
So the notification has must have been attached in the documents, sir, in
Annexure
front of you.
B1,
You don't have the
Annexure
copy of the, you don't have the writ petition copy either in
Yes,
hard
Yes,
copy
sir.
or soft copy?
Yes, sir. I have
Has
it in the soft copy.
Whether
sir.
it is not annexed to this writ petition?
Yes,
Yes,
my
sir.
lord.
It has been annexed. Sir.
Yes.
Page number 17.
Annexure B1. Yes, sir.
Page?
17.
Page?
17.
17. 17.
17, sir.
So why you are moving this writ petition when this notification was issued on 27th of February 2025? Today?
Sir, so we are moving this because we have not been provided the admit card, which was provided in the month of November to the other eligible candidates. And we were informed on 21st of November that we are not eligible since our internal reports, the ACR, has found that in the period of 2023 to 2024, our candidate had an ACR of below good, and they require at least good level. However, this was not provided in the notification. Rather, the notification had provided that after the CBT has been conducted for the final selection stage, only then the ACR would be considered for the last 3 years. Further, Your Lordship, it is also submitted that
After
just
which
last
is
year,
provided at which stage? After
the
which
final
stage?
stage after the written examination as well as the other examinations are conducted. So the only 15% is the weightage of the ACR at the end, sir. 65% comes from the CBT, rest from the interview.
Where is where this is provided in the promotional notification? Notification relating to promotion?
Yes, sir.
That
Just a second.
after written examination, this ACR is to be assessed or is to be considered.
So this is provided under the methodology and other norms, which is section 6 on page 22 of the writ petition.
In the notification, it is not there.
It is there, sir. It is the page number from the notification itself. I'm referring the page number from the annexure. So the
24.
page number is 22, sir. The heading is methodology and other norms.
Yes.
And in the point number 6 at the end, Your Lordship, you can see that it says that the final promotion or merit list will be based on the total marks secured, and out of 100 on the weightage comprising of written test 65%, qualification 10%, experience 10%, and ACR 15%.
So therefore, your contention is this based on the methodology under clause 6, Roman 6,
6.
that the ACR marks relating to ACR is to be considered at the
Final stage.
not at the stage of written examination, but
Yes, sir.
it is after that.
Yes, sir. And there is another point, Your Lordship, which is on page 21. I think It is the next page.
Yes.
So it is page number 23, general
Yes.
information and instructions. There is under Roman 3, sir, it has to be noted that the admit card will be generated prior to the CBT without scrutiny of the eligibility criteria of the
Just a minute.
notification.
Yes, just a minute. Yes, page 23,
Under heading 7, sir, Roman 3.
general information and instructions.
Yes, Your Lordship.
Roman 3.
Yes.
What is full form of CBT?
Computer-based test.
Yes. Now, where from you have come to know that due to gradation, which is good as you are submitting,
Yes, Your Lordship.
relating to ACR, admit card has not been provided to the petitioner.
So this was actually our client, the petitioner. He had sought some clarification regarding this on 20th November, and subsequent to that, on 21st November, there was a communication from the side of the respondents, which communicated the same, that due to the ACR being not being below good level, that is why we have been rejected. We have not been eligible for this examination.
Where is that communication?
It is, yes, sir. So the
It-
communication
E6.
is on page number
45.
45, Your Lordship.
Yes, page 45.
Your Lordship, I think the table is a little unclear in the copy
Yeah.
that I have, but in the hard copy, it must be visible on the column. The first name only, sir, Sridhar.
Yes, yes. When this was provided to you, 23rd of November.
This was received on email on 21st November.
21st.
Yes, Your Lordship.
My lord, may I provide a fairer copy, my lord?
Yes, anything more you want to submit?
Lordship, another submission that it must be noted by this court that while the claim says that the it was not found adequate, the ACR report says that it was below good. However, just last year in November 2024, the petitioner was also promoted from grade B to grade A in the same position that he's working currently as a junior scientist
The
assistant.
methodology may change in the subsequent year.
Yes, Your Lordship, this submission is just to clarify that this same ACR that they are relying upon, it was also used previously to actually only when it is found satisfactory can they be promoted. So it has been used in a prior promotion, sir, of the same petitioner. At the same time, the petitioner also submits that there are judgments of the Supreme Court as well, which do state that if the ACR has been kept confidential, it has not been provided, the candidate is not knowing what the ACR report is actually reflecting regarding the professional capacity of the person, then such ACR cannot be relied upon in a case of promotion if you are not communicating, because that goes against the interest of transparency. And that also makes the whole process arbitrary if the same is not communicated. So that is also another submission, Your Lordship, and we are
Yes.
just requesting to give a interim relief and allowing
Yes,
us to
yes.
appear for the examination, Your Lordship. The promotion can be subject to the
Yes,
outcome
why
of the writ
admit card
petition.
was not provided?
My lord, from the notification of the office order, my lord, I am providing only the candidates who are having poor eligibility, those are being
But
communicated.
that stage has not reached. That stage, as per your promotional notification, has not reached.
No, my lord, if
In the promotional notification, it says that the final promotion selection merit list will be based on the total marks secured by the candidate out of 100 marks on weightage comprising written test, qualification, experience, and ACR. So at the time of appreciation of the candidature of the petitioner based on the after the test and the marks which petitioners which the petitioner is allotted, um, considering those marks at the subsequent stage, you consider the ACR at that stage. But why you are not providing admit cards, debarring the petitioner from participating in the written test?
my lord, my lord, my lord, I'll bring
Your notification says otherwise.
no
It
notification, my
says
lord.
that there are two clauses, relevant clauses, as pointed out by the learned advocate representing the petitioner, that the final promotion selection merit list will be based on the total marks by the candidate out of 100 marks on the weightage comprising written test, qualification, experience, and ACR. Performance rating should be at least good for the last 3 years.
3-10 years, my lord. That's 21-22, 22-23, and 23-24.
Performance rating
He
should
had good rating in 21-22 and 22-23, not in 23-24.
Lordship, but the promotion did happen in 2024. So that must have taken into account.
for the last 3 years under review. Please. Last application not having. Yes, but you have not placed the entire methodology of clause 6 Roman 6, madam. You have
Yes,
not
Your Lordship.
you have not placed the entire Roman 6.
It has been
Subsequently,
placed,
it
Your
is say
Lordship.
no. Performance rating should be at least good for the last 3 years under review. That is 2021, 2022, 2022, 23, and 2023, 2024.
My lord.
Average,
That is true.
adequate, barely adequate will not be considered fit for selection.
Yes, sir. Your Lordship, the word they're using is selection. They're not saying that
Moreover, it is also clarified that thus applicants who are not having desired performance ratings for last 3 years as on the cutoff date will not be considered.
My lord, in
Lordship, I think Lordship, the interpretation should not be lost over here, because Your Lordship, when we are reading the entire provision, it is pretty clear that they are stating this selection because they are only referring to the person as an applicant. They are nowhere saying qualified person even in the entire notification. So it has to be cleared out that the word applicant has only been used for any person who is applying for this position. However, they're using the word selection. So these candidates shall not be selected. However, that selection occurs after the CBT. The final selection is only under consideration for that. Your Lordship.
No. In clause 6, Roman 6, clause 6.
Yes, Your Lordship,
It
I'm
is
reading the same.
clarified that the performance rating should be at least good for the last 3 years.
Exactly.
2021,
But,
2022, 2023, 2023, and 2024, 2024. Average,
Your Lordship.
adequate, barely adequate will not be considered fit for selection. Thus, applicants who are not having desired performance ratings for last 3 years as on the cutoff date will not be considered.
Yes, Your Lordship, but as I had also stated about the point number 7, the general information, it is providing that these things do not have to be considered for appearing
This
at the
is for
stage of
general.
appearing.
This is for general instructions.
Yes,
But
sir,
you
but
have, but so far your eligibility is concerned, that has to be assessed on the basis of ACR.
sir, another thing is the submissions that are made, so that the ACR which was not
This
communicated
is for
because
abundant precaution, madam. This has been done under
I
clause 7.
understand, Your Lordship.
That
Lordship,
if
the only
there is
point,
an issuance of admit card, that will not confer any right upon the candidate to be considered.
I understand, Your Lordship.
So you should have,
That is
you
why
should
we
have,
also
you
made a
should have,
submission.
you should have placed the entire clause 6, not in a piecemeal way. Is it the
That was
way
not
to
the
place your
intention,
case?
Your Lordship. I'm really,
Should
I
have been candid
apologize for the
before this
same.
court.
However, Your Lordship, just one,
I
that is why
don't
I also
find any
submitted.
candidness so far you are concerned. So we have only placed the part of the relevant Roman 6.6. And
Your
is
Lordship,
it,
just one more
and this
submission,
is
Your Lordship. The
indisputable
same candidate
that
was also
the
promoted
ACR
based
rating
on the
is
report of
below good
2023
for
to
the year
2024.
2023-2024. Sorry, Esho.
Lordship, just one submission, Your Lordship. We had also submitted
Matter
that the
is flawed
same
in presence
candidate.
of the learned advocates representing the
Lordship,
petitioner and
may I please request one?
Coal India Limited,
Lordship, we have
being
also
the
placed on record
being the
the
answering
same person was also
respondent.
promoted on the basis of the
Petitioner is
2023-2024
by the learned
ACR
advocate on
report, sir.
virtual
If
mode.
it was not
Stop.
satisfactory, how would the person be promoted?
Matter relates to non-supply of admit card for participation of the petitioner in promotional examination, which is scheduled on 25th, which is scheduled on
29th.
Saturday,
It's at 29th, my lord.
which is
29th,
scheduled
November.
on 29th November 2025.
Lordship,
In terms of notification dated 25th February 2025.
Lordship, the
And
ACR
the
report
Act
was
is on
also
to
not.
notification, my lord,
Lordship, can I
under
please?
7 in the general information and instructions, 7 subclause 9. It specifically provides that if at any stage the promotion, selection, or subsequent is found and the applicant has provided wrong, this I am go by. B, suppressing, this has to go by. C, does not meet the eligibility criteria of the promotion selections. That is already
The eligibility criteria, Your Lordship, it has to be noted the eligibility criteria is not providing ACR in the notification. The eligibility is provided in the table in the notification, and it clearly states that it is only in terms of the educational
specifically
qualification,
mentioned
Your Lordship.
the
So this
notification,
point
my
cannot be taken in.
Mm,
And Your Lordship, moreover, the ACR report was never communicated to us.
yes.
And we were also promoted in
Yes.
2023 to 2024 on the basis of that
Absolutely.
report only we were promoted last year, Your Lordship. So that has to be considered. If it was poor, why would a non-executive position be promoted?
Stop.
If the report was poor, and the same report was not communicated as well, and it cannot be relied upon according to the in the submissions, the judgments that we have provided, Your Lordship. And the point about under general information cannot be taken up because the eligibility is
Stop.
clearly being met according to the notification, Your Lordship.
It is submitted in reference to a document at page 45 of the writ petition that ACR rating,
my lord.
annual
Confidential.
Annual
Confidential.
confidential report.
it is submitted in reference to a document at page 45 of the writ petition that as annual confidential report within bracket ACR, for short ACR করে দাও, for short ACR, that as per annual confidential report for short ACR, petitioner was found to be petitioner was assessed below good for the year 2023-2024.
So such assessment was not
He
communicated.
was not
It was not
supplied,
communicated, and we were also
admit
promoted
card,
last year on that basis
thereby
of the report.
permitting him to participate in the ongoing written test or participate in the ensuing written test on 29th on 30th November 2020, 29th or
29th
30th,
November.
madam.
on
29th.
29th November 2025. Stop. In order to buttress the case made out in, by the petitioner, it is submitted that assessment of the candidate as per ASIA needs to be carried out not at the stage when written test is to be conducted, but at the subsequent stage while assessing marks awarded to the petitioner under written
Lordship,
test,
the ACR also is challenged over here.
qualification, experience, as it is provided under clause 6 within bracket Roman 6 of the notification dated 25th February 2025. Next one. In addition thereto, it is also attention of this court has been drawn to clause 7 within bracket Roman 3 of the notification dated 25th February 2025, wherein it is provided or where under it is provided that mere issuance of admit card before computer based test within brackets for short CBT close bracket does not confer right to the applicant to be
Lordship, this eligibility has to be as on the cutoff date, which is provided to be 31st January,
eligible
not after that.
for promotion / selection if he is otherwise found to be ineligible.
Lordship, ineligibility has to be only considered
Stop.
till the cutoff date and not after that.
Therefore, according to the petitioner, in terms of the aforesaid relevant provisions or in terms of the aforesaid provisions as indicated in notification dated 25th February 2025, petitioner ought to have been supplied admit card permitting him to participate in the ensuing written test or in the ensuing computer-based test on 29th November 2025. Stop. Next paragraph. Learned advocate representing Coal India Limited has opposed this writ petition based on the
Lordship, it must also be taken on record that
based
the
on
same
clause 6
candidate
within bracket
was
6
promoted prior on the basis of the
the
same
notification
report
dated
that they are
25th
using
February
right now.
2025, which is relied upon by the which is relied upon on behalf of the petitioner, and clause 7 within bracket 9 Roman 9 within bracket C. Stop. It is further submitted that as the petitioner, as per ACR, was found to be below good for the year 2023-2024, he is not eligible to participate in the ensuing computer-based test.
Lordship, the eligibility criteria provided in the notification in the table must be considered, not the clause that they are claiming. It is not actually coming under the ambit of the same, because we are clearly eligible according to the criteria that has been set in the notification, which can be found on page number 18.
Moreover, as per clause 7(9) Roman 9, if the candidate fails to meet the eligibility criteria for the promotion/selection, right is reserved by the respondent authority to disqualify any candidate. Stop. Having considered, next paragraph, having considered the submissions made on behalf of the parties and taking note of the relevant provisions as contained in the notification dated 25th November 2025.
Lordship, just
This
can
court
I just
finds it
request
at
to have just 10
That is
seconds of
25th
your time,
February,
Your
my lord.
Lordship, please?
28 February 2025.
Lordship,
This
can I
court
just have
finds
10
it at
seconds of your time?
to rely upon clause 6 within bracket Roman 6, and same is quoted below. Page 22, clause 6 Roman 6 টাকে পুরো কোট করে দেবে। Stop. In order to appreciate eligibility of the candidate, eligibility of a candidate to be considered for departmental promotion, said clause 6 within bracket 6 needs to be considered in its entirety.
Lordship, but the ACR cannot be relied upon has been provided in a lot of judgments
It is true
of the
that
Supreme Court itself,
first
that the
part of
ACR which
clause
was not communicated
6 within
cannot be
bracket
relied
6
upon just to understand the
provides
eligibility of a candidate for the exam.
that the total marks allotted for promotional examination or promotional process, or total marks allotted for the promotion is 100, out of which for written test (65) is allotted, comma 10 marks is allotted against qualification. Now 10 marks each is allotted against qualification and experience, and for ACR 15 marks is allotted.
Lordship, this in itself is showing that this is just for the
Stop.
final computation. It is not for the eligibility. Otherwise, ACR would have come first for the same.
But clause 6 within bracket 6 does not end here. It is also provided therein that performance rating should be at least good for the last 3 years under review, that is 2021-2022, 2022-2023 and 2023-2024.
And Lordship, the 2023-2024 report has been relied upon to give him the promotion last year.
It is further
If it was
specifically
poor, the
provided
promotion
therein
would not have happened.
that if
That
a
is why the
candidate
ACR is
is
also being
assessed
challenged here, Your Lordship.
as per ACR, average, adequate, quote unquote করে হ্যাঁ, average, adequate, barely adequate, quote unquote, will not be considered eligible for selection.
For selection, Your Lordship,
And
not for giving
the
the
candidates who does not have desired performance rating PR করবে capital.
Lordship,
For
Lordship,
last 3
one more
years,
thing, the
as
last
on the
sentence
cutoff
also has
date
to be
will not
considered,
be
Your Lordship, that the applicants who are not having desired performance for the last 3 years as on the cutoff date will not be considered.
Next paragraph. In addition thereto, under general information and instructions as provided under clause 6, it is specified under subclause Roman small 9.
My lord, it will be 7, my lord. 7.
No. Subclause Roman 9. 7-9.
7-9.
কি বলছিলাম? Under clause 7. 9.
Lordship, the last statement, the clause that you're relying upon in clause 6, the last statement also has to be noted. It has to be considered over
if
here.
at any stage of
About the
promotion,
cutoff date, Your Lordship.
if it is found that the applicant does not meet the eligibility criteria for
And Lordship, the eligibility criteria
not
is
meet the
nowhere
eligibility
providing
criteria,
ACR to be an eligibility for sitting
he/she
for the
will
examination,
be
Lordship. It
liable,
is just for the selection.
he/she is liable to be disqualified. Stop. Next paragraph. Court is not considering correctness of assessment made by the respondent authority based on ACR in the present case.
Lordship, the
Therefore,
ACR can
court has
be
to proceed
questioned later on.
based
However,
on
we have to
ACR
consider.
rating as given to the petitioner for the year 2023-2024 as it appears from a document at page 45 of the writ petition, which goes to show that petitioner was assessed below good.
Lordship, kindly do consider Annexure
Below
P4
good,
also
quote
on
unquote,
page
below good.
43. It is provided that when the same person was also promoted, and that promotion, if you have a poor record, how
While
would you be
considering the
promoted in a
eligibility of the
non-executive
petitioner
position?
to be considered for promotion by permitting him to participate in the participate in computer-based test, court cannot brush aside this aspect, taking note of the provisions as contained under methodology and other norms, quote unquote, in clause 6 within bracket Roman 6, wherein it is unequivocally
It is still not
stated
a eligibility criteria for
that
the exam, Your
average,
Lordship.
adequate, and barely adequate will not be considered fit for selection,
Lordship, but there is no, there is only arbitrariness in this entire situation,
and
as we are
candidate
seeing.
has to be assessed at least good, quote unquote,
At
for the
least
last
good,
3 years
Lordship, if for
under
the non-executive promotions
review,
also, the
that is
same criteria is there
2021,
that the
2022, hyphen 20, comma,
rating has to be at least
2022,
good.
2023,
If it was not present,
and
how is the same
2023,
candidate
2024.
promoted just last year, relying on the same
Next
exact
paragraph.
report in which they are saying that the rating
In
is
view
below
of
good?
aforesaid scenario, court is not inclined to allow the court is not inclined to pass order permitting the petitioner to participate
Lordship, it would be a great, Lordship,
in the
it would,
ensuing computer
Lordship,
based
the
test.
exam is on 29th. The
Writ
subject
petition
to
stands
this writ
dismissed by
petition,
the
Lordship, it has to be considered, Lordship. This cannot be done by this court, Your Lordship. It is rather arbitrary if you're not communicating, and we have also relied on
Where is
judgments
the
from the
can?
Supreme Court, Your
What is the
Lordship.
can for?
Can,
Can देखिए
for interim order, my lord.
Lordship, an interim order can please be passed in this matter, so the candidate can at least appear in the examination on 29th,
application
Your
in
Lordship.
can 1 of 2025 is also dismissed. হ্যাঁ পাসওয়ার্ডটা দাও
Password matter item number 1.
Lordship, and item number 3,
Yes,
can
are
we
you
please
objecting?
request for a dusty copy of
And
the order,
proceed.
Your Lordship?
Matter is accommodated in the list under the heading to be mentioned. On
Lordship,
being
just a
mentioned by
request for the
learned
dusty
advocate
copy, Your
representing
Lordship.
the petitioner. Stop. Learned advocate representing the petitioner submits that the petitioner does not want to proceed with the matter. Stop. In support of same, a letter dated 11 July 2025 is placed before this court and same is taken on record. Next paragraph. Respondents, you are representing
The Calcutta State
State-
Transport Corporation.
Yes. Calcutta
One is
Transport Corporation. Don't say state transport.
Calcutta.
Yeah, Calcutta State Transport
State
Corporation.
Transport.
Yes. Calcutta State Transport Corporation is represented by learned advocate. Stop. In view of the submission made on behalf of the petitioner, writ petition stands dismissed. Interim order, if any, stands vacated. Stop. Stands dismissed on the ground of non-prosecution court. Interim order, if any, stands vacated. Parties to act on the server copy. Next.
Lordship, just one request for the item number 3.
Sir, I
Can
am
dusty
for this
copy be
case led
issued
by
for-
Advocate Orindam Mitra. He is not appeared today due to some personal
দেখি ফাইলটা দাও
being for not today.
ফাইলটা দাও
That's number.
Four.
Oh, sorry, sir.
Lordship. Lordship, we are requesting, Lordship,
Item number
Lordship, we
4.
are just requesting for the dusty copy to be provided, Your Lordship. For item number 3.
At the time of. Are you appearing in this matter? Wait a minute.
Person to murder.
Time of.
Person to murder.
Yes, Mr. Mohan. Just a minute. Time of. Report?
It would have been better to buy an affidavit.
Yes, yes.
It would have been better buy an affidavit. I've asked yesterday, when you file a report supported by an affidavit, because under the Evidence Act, if it is taken into concern, if my loved ones, my officer is present, but in course of today, it will be affirmed.
Yes, what is the matter about?
My lord, the principal point where my lord has all the report from is that, my lord, they didn't give me hearing of the show cause notices as was directed by the earlier coordinator. My lord, may kindly comes to
Show cause notice.
show cause notices, my lord. I have replied to that. They have admitted that in their report. My lord, may kindly comes to page number 10. My lord, may kindly comes to page number 98 for once. My lord, that is the order of the earlier coordinate bench. Now, my lord, the earlier coordinate bench direction was twofold. First, release of my salary, and secondly, my lord, to hear me on my show, to direct me to give a reply to the show cause notices, and then to hear me and take a conclusive decision as to why I was not being terminated, but why I was being stopped from doing my work. Now, my lord, if your lordship kindly takes
Just a minute.
now, my lord, my prayers.
Just a minute. Okay. You are working in as Anganwadi helper,
Worker.
as Anganwadi worker.
Worker.
Now, a show cause notices were issued on 9 January 2024, 1st December and 9 January, 1st December 2023 and 9 January 2024. Now, you prayed for a direction which would permit you to appear before the CDPO. Respondent number 4. Yes, that is the prayer, page 12. Come to page 12.
Page 12.
Yes, ma'am. The hearing of my show cause notices and my
Okay.
regularize my salary. Directing the respondent number 4 to give a hearing to the petitioner on basis of hearing.
Now, what is the present stage of whether any proceeding has been initiated against the petitioner based on these two show cause notices?
Kindly comes to the
Department proceeding has not been initiated. Let her join immediately.
Let her?
I've suggested my officer, let her join duties immediately and perform her duties. He want a helper. It is not possible for the government to appoint a helper. Helper sanction post is available.
So at present, she is not attending Anganwadi center.
May I say this, my lord? I don't know, my lord, subject to correction from my learned seniors and my lord. What my instruction is, my lord, the school in which I am engaged.
It's not a school.
My lord, the workplace which I am being engaged.
What is that? It is not workplace.
My lord, the
It is workplace, Anganwadi center. Yes.
Supply the forms.
Anganwadi
Yes.
center, my lord, I stand corrected by your lordship, my lord. The Anganwadi center in which I am engaged, my lord, no articles are being supplied by the CDPO, my lord. Nothing are being supplied, my lord. The workplace is not in a working condition by the CDPO, my lord. That is my instruction, my lord.
So improvement of working condition by providing further infrastructure and appointment will be considered later on. But first you join the
I am
center.
always open to join, my lord. My lord,
When you are not joining,
my lord.
when you are not joining and work and functioning as Anganwadi worker.
My lord, I am an Anganwadi worker.
Yes, why you are not attending the
Lord,
center?
I am attending, my lord. There is an online portal now in which we have to give our regular attendance, my lord. That portal has also been stopped by the CDPO, and for that reason, my lord, there are representation annexed to the.
From which date you are not working?
My lord, I am working regularly, my lord.
You are not giving attendance.
I'm attending the center, my lord.
You are not giving attendance
No, my lord.
on the portal.
For that reason, my lord, I'm regularly emailing.
From which date the attendance is not being recorded on the portal?
The exact date is I am not being instructed, my lord.
Yeah, why?
My lord,
That is a relevant consideration and a relevant fact from
my lord,
which
before
date
filing of this
your
petition, my lord.
from which date your attendance is not being recorded on the portal.
My lord,
Tell me.
before filing of this petition, before filing of this petition, my lord, page number 19.
And you are not getting salary.
No, I'm not getting salary, my lord.
So if you are not getting remuneration, then join and pay, and
My lord,
I will
my lord
direct
may
authority.
direct that, my lord may direct that, my lord may direct is to the center to become in a workable condition, my lord. I have no objection to join.
What workable condition?
My lord, nothing, no food grains are being supplied to the center, my lord. What will I do while joining there, my lord? My portal is also being blocked by the CDPO, my lord. That is my instruction, my lord. The portal is also being blocked, my lord.
But that is not the sum and substance. That is not the sum and substance of this writ petition. No prayer is couched to that effect with the prayer which you are now for making before this court. What is the prayer? Prayer is to permit you to appear before the CDPO to make deliberation based on two show cause letters dated
Because, my lord, I had to show
1 December 2023 and 9 January 2024, and the other parties to pay salary and to appoint one
because, my lord,
helper.
because, my lord, I had to take proof
So therefore the other prayers are not there. Court will not enter into this.
Because, my lord, my lord,
Now, are you in a position to join the center? Yes or no?
Yes, my lord.
So then how his attendance is to be recorded? Tell me, Mr. Mukherjee. If the portal is not alive so far this Anganwadi center is concerned.
Just keep it.
সে করলে করতে পারবে, কাজ করলে ভালো করে করলে করতে পারবে।
When I is ready. Later join by tomorrow or day after tomorrow.
But then I will go to the CDPO's office and join, my lord, not in my workplace, my lord, because my portal.
No,
Everything will be provided to you so far the portal is concerned. Go and join there.
My lord, I will join directly the CDPO's office, my lord.
When you will join, please tell me.
My lord, from whom? My lord, that I will have to take instruction. My lord, may direct, I can join from tomorrow because they are regularly going to the center, my lord. What I have instructions, my lord.
Tell me that when you will join.
My lord,
I will direct the CDPO to make the portal alive again so that you can record your attendance. But tell me when you will join.
Any day your lordship direct. Any day your lordship direct. Well, I will instruct my client accordingly. I will request my client accordingly, any day your lordship direct.
Mr. Mukherjee, I am placing this matter next week. You obtain instruction and come back that whether you are in it appears to me that you are not in a
my lord,
you are not willing to join.
No, my lord, I am willing to join, my lord. My client is there, my lord. Kindly keep this matter next
my officer is there. My officer is there.
My client has
They
not
want food to be supplied to the.
but on the next week, my lord, I will call my client also, my lord. My lord, kindly keep this
So
matter.
then very well let me dispose of the writ petition directing the petitioner to join the Anganwadi center by fortnight from date.
My lord,
And if you join, I will direct respondent number 4 to make the portal alive for recording your join.
My lord, kindly.
And if you join and if you go on functioning as Anganwadi worker, in that event, remuneration in accordance with law will be paid.
Whatever, but
my lord, my back remunerations are not being
that will be considered later on. You make a representation regarding back wages. Back remuneration has to be considered. It's a factual issue. Whether you in your own volition did not attend or you are prevented, that has to be considered.
For that reason, I need a hearing, my lord. For that reason,
Yes, sir.
Then my lord may kindly gives me that liberty to give me a representative for
Yes,
back
that liberty I will. Report is filed.
Well, my client is also present, my lord. I am also.
So ask her and tell me.
My lord, from tomorrow itself, my lord.
Very well. Report of কি বললাম? Report is report dated 26 November 2025 of Child Development Project Officer. It should be ICDS project. Child Development Project Officer ICDS project Rajarhat, and same is taken on record. Matter is heard in presence of the learned advocate. Rajarat being respondent number 4. বুঝলে? ওখানেই respondent number 4 করে দাও, বুঝলে? Child Development Project Officer is right, Rajarat. Matter is heard in presence of the learned advocates representing the petitioner and state respondents. Stop. Mr. Tapan Kumar Mukherjee, learned additional government pleader, representing the state respondents, has fairly submitted that if petitioner joins as Anganwadi worker in Anganwadi in the concerned Anganwadi center, in that event, petitioner will be permitted to function as Anganwadi worker, and necessary steps will be taken for which would facilitate the petitioner to work as Anganwadi worker. Stop. It is also submitted that since petitioner is not attending the Anganwadi center, remuneration is not being paid to him. Her remuneration is not being paid to her. Stop. Next paragraph. Learned advocate representing the petitioner submits on instruction that petitioner is willing to join as Anganwadi worker in the Anganwadi center immediately. However, it is submitted that unless the portal is made alive or unless the portal is revived, attendance of the petitioner in Anganwadi center will not be recorded. And in spite of attending Anganwadi center, petitioner will be treated as absent.
Well, only one thing,
Stop.
Senior advocate submission that I am not doing, I dispute that, my lord. Kindly records that, my lord, because that will create a barrier for me in the future, my lord.
Next paragraph. Having considered the submissions made on behalf of the parties, court directs the petitioner to join Anganwadi center as Anganwadi worker on 1st December 2025.
By that time, the portal should be made alive, my lord.
On 1st December 2025, please wait, hear the order, and then if anything is left, then you indicate. Stop. Respondent number 4 is directed to revive the portal on which petitioner will record her attendance. Stop. After joining of the petitioner as Anganwadi worker, remuneration in accordance with law shall be paid to the petitioner on monthly basis. Stop. Next paragraph. However, it is submitted on behalf of the petitioner that though petitioner attended the center regularly, but as the portal was not alive, her attendance could not be recorded. Stop. Therefore, prayer is made for directing the concerned respondent authorities to pay ADR remunerations. Stop. Considering the submissions made, considering such submission made on behalf of the petitioner after her joining on 1st December 2025 as Anganwadi worker, petitioner shall be at leave to make a representation to respondent number 4 seeking release of ADR remuneration by fortnight from the date of joining. Stop. If such representation is made, respondent number 4 shall decide the same in accordance with law by 8 weeks thereafter, after granting opportunity of hearing to the petitioner or her representative, and a rescind order shall be communicated to the petitioner by 10 days thereafter. Stop. If it is, next paragraph, if it is decided by the respondent number 4 that petitioner is entitled to receive area remuneration, consequential steps shall be taken by the concerned respondent authorities for immediate release of area remuneration. For immediate release of same. Next paragraph, with the aforesaid directions, writ petition stands disposed of. Next paragraph, leave is granted to the learned advocate for the petitioner to communicate this order immediately without waiting for server copy of this order.
My lord, in item 5, Mr. Orindo Mitra is appearing for the state. He is very sick, my lord. He is not able to come to court, my lord.
So when he will be able to come to court?
My lord,
Tomorrow.
kindly make it not today. He will come.
Tomorrow he will be able to come.
My lord.
But today is very not today.
Grateful, my lord. Grateful, my lord. Item number 7.
See,
My lord, I am for the respondent, my lord. My lord, I am for the petitioner for item number.
yes.
My lord, I am for the petitioner for item number 7. My lord, Advocate Shayan Mukherjee is appearing in this matter. He is in another courtroom, my lord. My lord, if your lordship kindly takes the matter after 2 or makes it not today.
Not today.
Grateful, my lord.
Item number 8.
My lord, I appear for Life Insurance Corporation. My lord, on last occasion, my lord has directed the department to tag the modification application that was not appearing in the file. Perhaps that has come by now. My lord, the basic small facts of the matter is that these are those batch of writ petitions challenging 2009, including 2016's development officers rules. Now, my lord, in this particular matter, there was an interim order that was granted on 10th of July 2025. Challenging that order, we have filed an appeal before the Honorable Division Bench. Now, my lord, in batch of matters, appeals were filed. One of such matter in the Honorable Division Bench has directed us to come back to to this court and file a modification application. That we have already done, and that is appearing in as item number 84 and 111 in my lord's list, monthly list. Now, my lord, in this particular matter, the appeal was not taken up for hearing. However, we have already filed the modification application. Now, the same self order cannot be sought for modification as well as the appeal is pending. So we have taken steps for withdrawal of that appeal. Now, my lord, the appeal, unless and until I withdraw.
In this matter, you have preferred appeal.
Yes. But what has happened? 3 appeals were preferred, 2 were taken up. Court directed to come back and file modification. We have also filed in the 3rd application, but at the same time, both cannot run parallelly. So we have to withdraw the appeal that is pending. We have mentioned it.
So against this order
of 10th.
Which order you have preferred?
10th July 2025.
You have preferred appeal?
Yes.
So that appeal is pending?
That appeal is pending. Plus, we have also preferred a modification in terms of the subsequent view.
Connection with the appeal?
In connection with this order before this honorable bench. So, I have to withdraw the appeal before moving my modification application, because the same self order cannot be sought for modification as well as when the appeal is pending. Technically, I cannot. So, I have already mentioned it before the honorable division bench to withdraw my appeal. My lord, that appeal has not come up for withdrawal. So, what I was just beseeching, let this matter stand over for at least 1 week or 10 days, because department is identifying the files. And he is protected. Otherwise, he is protected with the interim order. Yes,
Lord,
and just to update, my lord.
এটা কবেকার order? হ্যাঁ। My lord, the matter, my lord, the issue, my lord, is pending, my lord, before the Honorable Apex Court.
My lord, will address when item number 80.
Yesterday, my lord, this was taken on 24th. Yesterday. On 24th, this was taken up. The SLP was admitted.
SLP, no.
Dada.
Let's put it in a correct manner. SLP admitted long back.
No.
So, my lord, may I just give a very short background? Challenging this.
Wait.
Yes, very.
Admitted.
Admitted অনেক আগে।
না, admit হয়নি আগে। আগে adjourn হয়েছিল আগের দিনের অর্ডারটা।
না, হিতেশ কুমার গুহ। Same matter. First order টা দাও this one.
Let the matter go out of list. In view of pendency, after the
My lord,
matter is,
may I-
sorry,
No, my lord, may I just?
and the coordinate bench also directed, specifically observed. I also passed
Yes,
an
yes,
order.
yes.
My lord,
In view of the above, since the issue is pending before the Honorable Supreme Court, the judicial property demands that a hearing of this writ petition should be adjourned for the time being until the issue is finally decided by the Honorable Supreme Court.
Correct, my lord, but at the same
Yes, sir.
time, my lord will appreciate that Supreme Court has never granted.
Matter is heard in presence of the learned advocates representing the petitioner and Life Insurance Corporation of India Limited. Yes, it was fixed on 24th of
Yes, my lord.
December in terms of
24th, my lord. On the last occasion, it was
all
adjourned.
matter will go out of list.
My lord, wait.
হ্যাঁ কি বলছিলাম representing the petitioner and Life Insurance Corporation of India Limited or Life Insurance Corporation of India, stop. During course of hearing, order passed by the Honorable Supreme Court on 24th November 2025 on a special leave petition within bracket civil close bracket diary number 6366/2025 arising out of final judgment and order dated 20 December 2024 in writ petition number 30491 of 2024 passed by the High Court of Judicature at Allahabad is placed before this court and same is taken on record. Stop. Video order dated 24th November 2025. Honorable Supreme Court directed to issue notice and the matter was made returnable on 20 January 2026. Stop. Next paragraph. In view of pendency of similar issue before the Honorable Supreme Court in connection with special leave petition civil diary number 6366/2025, let this writ petition go out of list with liberty to mention.
Grateful, my lord.
We record that there is no stay that has been granted by Supreme Court in this matter.
My lord, there cannot be.
Issuance of notice is sufficient.
But my lord, stay of
Issuance of notice is sufficient. No, so far Supreme Court is concerned, no, there is no specific direction required for stay.
My lord, stay cannot be also, my lord.
Yes.
Since, my lord, these.
Against the Allahabad High Court judgment, this this SLP was preferred and the
Well,
notice issued.
And my lord, the difference is, my lord,
Let all the issues be kept pending till Supreme Court decides the issue.
my lord, grateful.
Item number 9.
9, my lord, I appear for the petition.
Service.
My lord, we had served upon the victim lady. Lordship would remember, my lord, last in the earlier writ petition, my lord, by mistake, we had disclosed the particulars. My lord, we have filed a. So we have served upon the victim lady. It has come back with the endorsement insufficient address. Lordship would remember, my lord.
Victim lady is the employee of this court. So Mr. Kaur, please take steps so that the service can be effected upon the.
I've been instructed to appear in this.
I think they have served through the registrar.
Yes, up to the register and requirement is for me a copy.
My lord, my lord, it is the recommendation, my lord, of the internal complaints committee of this court. My lord, the recommendation, my lord, there were 2 recommendations as against me. My lordship would get those recommendations at page 244, volume 2. My lord, 243.
Now complying rule, now you have filed this writ petition.
Well, it was, my lord, we had written to the Registrar General of this Honorable Court as to whether there is an appellate authority, my lord, against the order of the, my lord, there is no, my lord, we have not been responded to that whether there is any appellate authority or not. Now, my lord, kindly comes to page.
So you are challenging the recommendation of
my lord, passed by the POSH committee of this Honorable Court. Now, my lord, the recommendation, my lord, has two parts. First is, my lord, registration of an FIR as against, my lord, this petitioner. My lord, the FIR has been registered. My lord, we have surrendered, we have been granted bail. So, my lord, that part is good. Second part is, my lord, payment of rupees 50,000 compensation. Now, my lord, in favor of the victim lady. Now, my lord, what I was only beseeching your lordships, my lord, if that 50,000, my lord,
Where is such recommendation?
Lord, kindly comes to page 243, volume 2. But kindly comes to 3. Even though exact quantification of the pain and suffering of the complainant cannot be assessed in monetary terms, but to put balm to the mental trauma, pain, suffering, and emotional distress, the committee thinks it appropriate to recommend payment of monetary compensation to the complainant for the persistent sexual harassment suffered by the complainant at the hands of the respondents jointly and severely. The committee has taken a note of the fact that the sexual harassment affected the health of the complainant and she had to incur expenses. Then 4, it is recommended that the respondent number 1 pays compensation to the tune of rupees 50,000.
So this recommendation was made on 26th August 2025.
Yes.
And the time schedule which was fixed is 30 days. So that has expired long back.
But we received this recommendation.
Already it has been recovered from the salary of the respondent number 1, 2, and 3.
No,
But
he
the
has
respondent
retired.
number 1 has retired.
The petitioner, the present petitioner has retired. This Mr.
So number 1, before the POSH committee retired.
Yes, my lord, before the POSH committee
petitioner
proceedings were
in this,
concluded.
there are 2 writ petitions today in court. Lord, the petitioner in this petition, he has retired.
But I have retired on 31st of October 2023.
Yes. Now, what is the basis of your challenge to this recommendation?
What I was, my lord, mainly beseeching your lordships, my lord, that, my lord, may I be permitted, my lord, to deposit the amount as directed by the POSH committee before the Registrar General of this court. And, my lord, till such time, my lord, could this order be stayed and, my lord, affidavits be directed? But subject to a conditional deposit of 50,000 before the Registrar General as directed by the committee.
So it is to be paid to the victim and who is the employee of this court also.
Yes.
So is the difficulty. If ultimately matter is heard out, you pay the amount, let the matter be heard on affidavits. And if it is found that if your writ petition is allowed, in that event it is to be recovered from the salary of that victim lady.
But we do not actually know that when is she retired. But may I say
Yes,
this?
Mr. Court, when the victim lady is retiring.
I think she has couple of years more to go, subject to correction.
So I want to know the exact date of the retirement.
Check. Just give me two. Check.
Well, that is why I was praying if it could be placed before the Registrar General.
Let you
nationalized.
You can provide that in case she retires, we'll keep aside 50,000 rupees.
Both are the employees of this court.
Yes. None that can.
So let the amount be paid to the victim lady, and I will permit the parties to this writ petition to exchange affidavits. And thereafter, if ultimately writ petition, there will be a rider in the order that if the writ petition is allowed, that is to be recovered from the salary or retirement dues of the petition.
But in such time, my lord, this order, my lord, there is an FIR registered, my lord, based on this order. Now, my lord, could my lord, the operation of this order be stayed because there are consequential steps directed.
You have already obtained bail.
But I am on bail, my lord, but the criminal proceedings, my lord, because my lord, my basis is, my lord, if this order, my lord, at the end of the day, my lord, is quashed or set aside, my lord, by this honorable court, the FIR, my lord, which is registered on the basis of this order, my lord, that also goes. So, my lord, if the consequence.
There is a rationale behind it.
Yes.
I tell your lordship.
Otherwise, if suppose this writ petition is finally heard after some time, in the meantime, if criminal proceeding continues, then there will be difficulty.
There are prima facie grounds which is recorded in the order. Lord, I don't want to, Lord, show your lordship the documents today, but Lord, there is a letter which was written to the victim lady by this gentleman, which is one of the exhibits, and which is the prima facie basis of the committee coming to a conclusion that about the sexual harassment.
And my lord, we have
prima facie, therefore, Lord, the committee felt because he has retired, the other two, against other two, there is only, Lord, payment of cost of 10,000 rupees each.
Nothing else.
Nothing else. But Lord,
But so far the petitioner is concerned,
he is being held guilty of the offense. And Lord, the recommendation is that because he had retired, there is no question of, Lord, initiation of a proceedings. Therefore, Lord, the criminal proceedings have been directed.
Where it has been directed that to initiate criminal proceedings.
My lord, kindly come to
page 243.
43.
Recommendations.
Recommendation, second recommendation.
Just to. But if it is not stayed, Mr. Court, it does not make any sense. Ultimately, if the writ petition is allowed, in the meantime, if the criminal proceeding continues, then petitioner will be in difficulty.
Lord, in the meantime, supposing, Lord, ultimately the writ petition is dismissed, then, Lord, the criminal proceedings is going to be delayed. Lord, the other evidences which are there, Lord, the police can gather them.
Lord,
entire process will get stalled, Lord, if the criminal proceedings is stayed. After all, Lord, there are ways and means he can challenge the criminal proceedings. He can challenge the criminal proceedings, Lord, by filing a criminal revision application or whatever the method is. There are procedures, Lord, under the Criminal Procedure Code for the purpose of challenging a criminal case. But, Lord, in a writ petition where he is, Lord, challenging the recommendation, Lord, collaterally, I don't think, Lord, there is any scope to stay the filing the complaint which has been lodged. The FIR has been registered by the police based on the complaint. He has obtained bail.
If the part of this, or there are two parts for this recommendation is concerned. One is the payment of 50,000 rupees, and another is an FIR. The committee recommends the employer to lodge a criminal complaint.
Yes.
Now, and the lodging of criminal complaint. So far, the criminal complaint is lodged.
It has been lodged.
It has been lodged.
Yes, it has been lodged, already lodged. It is registered as an FIR. He has appeared and obtained bail in that criminal case. It is recorded as a criminal case. He has an independent right, Lord, to challenge the lodging of the FIR.
But if it is based on the post committee of High Court,
yes,
this is a difficulty. So far, criminal proceeding is concerned.
Quashing may be difficult, but Lord, if it is beyond the four corners of the statute on a technical ground, he can still go. There is no difficulty. Lord, great indiscipline has happened, Lord, in the institution. This is how the POSCO committee has.
Whether this, if the criminal, there should be a criminal investigation based on criminal complaints. If investigation is permitted to continue, but no coercive steps.
Coercive step he has already obtained.
May I suggest?
I'm not standing in the.
May I suggest something?
So far as Lord, coercive step is concerned, Lord, that's not the motive. I am not standing in the way.
And may I suggest something? Since it's a second, Dependent second. May I be permitted to say something? Let the investigation continue.
Yes.
But police will not file charge sheet without leave of this court. That can be done. The charge sheet, police will
Charge
keep.
sheet, I don't think the court should.
But that can be done.
If
Let
there
the
is
investigation
material,
continue.
Show me the order by which you have obtained bail.
Kindly comes to. Well, it kindly comes to page 257. I only have the surrender slip that I have surrendered.
257.
Page 257. By the learned Chief Judicial Magistrate, Kolkata. But what I was only praying is let the investigation continue. I shall not stand in the way. But no, police will not file charge sheet without leave of this court, subject to the result of the writ petition. That can be done because, my lord, if the investigation is concluded, the evidence
then
is
the
there.
materials can be collected.
Yes.
Lord, up to filing of charge sheet, there is no problem. Then kindly give him liberty to apply subsequently. Lord, if the police will not files a report, now, Lord, saying to close the investigation, the matter ends. The only issue would be then the 50,000 rupees. That is also a possibility. So, Lord, give him liberty to apply at a later stage. Once the charge sheet is filed.
Because, my lord, if the writ petition is not heard, then in that case,
As you are submitting, Mr. Kaur, that if at this stage it is stayed, criminal investigation is staged, or if no steps or the police authorities restrained from taking any steps based on criminal complaints, then the issue may be diluted due to efflux of time when the writ petition is pending.
Correct.
But instead of doing this, if the investigating agency is permitted to continue with the investigation and submit a charge sheet, but no coercive steps to be taken.
No, my lord, coercive
I'm not
steps.
standing in the
My lord, coercive steps is, my lord, I am already on. I am already on bail, granted by the learned jurisdictional magistrate. Now, my lord, if I am on bail, there is no, my lord, possibility that no coercive steps, my lord, cannot be taken as against me. If I was not on bail, there was a possibility that police can take coercive steps.
Now you have obtained bail.
I have obtained bail. My lord,
So then where is your apprehension? Let the criminal investigation continue and the charge sheet be filed. You fight out your case before independently before the criminal court.
May I say this? Now, my lord, what I was only beseeching your lordships, my lord, this writ petition, if it is not heard, and ultimately, my lord, the criminal case continues to a extent, and thereafter, my lord, I succeed in the writ petition, then in that case, my lord, this criminal proceeding has to go. My lord, no one knows, my lord, when this writ petition and after exchange of affidavits will be heard.
But this lady is due to retire on 31st of January 27, the victim. And Lord, the writ petition can be heard in January or February. Your lordship gives a.
But only, my lord, what I was only beseeching, my lord, let the police authorities conclude the investigation and, my lord, file charge sheet after obtaining leave from this court. That if this honorable court permits them to file the charge sheet, then in that case, my lord, the balance will be maintained because, my lord, so, my lord, in that case, my lord, I shall also have the urge, my lord, to get the writ petition listed and heard out.
The filing of a charge sheet does not take away any right of my learned friend.
No, my lord, filing of a charge sheet, my lord, prima facie holds me guilty of that offence. Because, my lord, the police authorities, as soon as police files a charge sheet, I am prima facie guilty of the offence, my lord, subject to, my lord, my trial. So, my lord, what I was only beseeching that if the investigation, let the investigation continue, police authorities will only file charge sheet, my lord, after obtaining leave from this honorable court, subject, my lord, to the status of the writ petition. That can be done.
When the court is not impeding the investigation, why the court should impede the filing of a charge sheet? Up to the filing of the charge sheet, there should be no.
But I am on that. Let it be
Give him-
up to the
give
filing
him-
of the charge sheet.
give him
But, my lord,
liberty
no
after
steps
that to
after,
apply.
my lord, the charge sheet is filed. The charge sheet may be filed by the police after obtaining leave from this court
No.
with regard to the status of this pending writ petition.
No, let the charge sheet be filed, but no further steps to be taken.
That,
in
my
connection
lord,
with the criminal.
that can be done. That can be done.
So that the groundwork is will be made
Yes,
ready.
yes.
Ultimately,
The trial is
if the writ petition is allowed, in that event there will be no initiation of criminal proceedings.
No trial.
No trial. And if the writ petition fails, then steps will
Let
be.
it be till charge sheet.
The presumption made by the petitioner that in trial for whether they have to face the trial. The lordship knows that. And the offence is made as of now in accordance with the FIR, then on the first instance the petitioner enlargement made. And whether the second stage is whether the charge sheet. And after filing charge sheet, the entire things required to be under the consideration of the persons or judicial authority in a trial. At least your lordship knows that what would proceedings. It will take huge time. That is not.
No, that is not the issue, Mr. Counsel. Problem is this: if ultimately writ petition is allowed, why petitioner will stand the trial? While petitioner will stand the trial. So that's why in petition at the same time court doesn't want to restrain the investigating agency from taking steps relating to the investigation, which is required to be made in terms of the leave granted by the post committee after the complaint, as Mr. Kaur has submitted it already, or that the criminal complaint has been lodged before the concerned police authority. So let the investigation continue, and if it is found that and the charge sheet be filed, and if petitioner is charge sheeted, and if it is found that there are materials against the petitioner, to that stage the court will not restrain the investigating agency. But if all materials will be made available, and after that there ought not to be any steps taken against relating to the criminal proceedings till the writ petition is filed. So that due to efflux of time, as Mr. Kaur has submitted, that the evidences may fade away. So that in order to considering this aspect, court is not minded to, or court is not inclined to halt the criminal proceedings or restrain the investigating agency from taking steps. So let the charge sheet be made ready and charge sheet be filed, but no further steps to be taken relating to criminal proceedings till the disposal of this.
And no one will be prejudiced by it.
The steps means your lordship is going to give petition upon exchange of
You tell me what will happen if the writ petition is allowed.
on prima facie case.
Sure.
The case has been made out
Matter is heard in presence of the learned advocate representing the petitioner, High Court administration, and victim lady. Stop. In the writ petition, a recommendation of
The internal complaint.
internal complaints committee. It starts from which page, Mr. Kaur? A recommendation.
But it starts from 212.
Honorable Committee Prevention.
Before Honorable Committee for Prevention of Sir, আপনি বোধহয় অন্যটা দেখছেন। 212. আপনি বোধহয় পরে
কি বলছিলাম? A recommendation of the Committee for Prevention of Sexual Harassment of Women at office slash workplace in the High Court, Calcutta, dated
26th August 2025.
Where from you are getting the date?
The Lordship would get it at page
At the end,
at the end.
last page.
245.
On page 244, the date is given at the bottom.
Yes, yes. Dated 24th August 2025 is under challenge.
So 26th.
Stop.
26th.
26th August is under challenge. Stop. By the আচ্ছা ওখানে ওই উপরে যে কমিটিটা বললাম হিয়ারিং আপনারা রেফার টু এজ দ্য সেট কমিটি করে দাও। On perusal of this recommendation dated 26th August 2025, it appears that respondent number 1 is which respondent here? Petitioner. That the petitioner it appears that the said committee recommended the employer to lodge criminal complaint against the petitioner under criminal law for causing sexual harassment to the complainant. Stop. In addition thereto, it was recommended by the said committee for payment of monetary compensation to the victim lady for the persistent sexual harassment suffered by the at the hands of the petitioner. Stop. The said committee finally recommended the petitioner to pay compensation to the tune of rupees 50,000 to the victim lady. Stop. Next paragraph. Having considered the submissions made on behalf of the parties and on perusal of the recommendation dated 26th August 2025, court finds that the said recommendation, that validity and legality of the said recommendation needs to be decided on exchange of affidavits. Stop. Next paragraph. Let affidavit in opposition to this writ petition be filed by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 1 week thereafter. Stop. List the writ petition under the heading hearing in the monthly combined list of January 2026. Stop. At this stage, court is not inclined to stay the recommendation, stay the relevant part of the recommendation by which petitioner was directed to pay compensation to the tune of rupees 50,000 to the victim lady, and same shall be paid by the petitioner to the victim lady by 7 days from date. Stop. However, it is made clear if writ petition is finally allowed, the amount of compensation shall be recovered from the salary / pensionary benefits of the petitioner or retirement benefits of the petitioner. The retirement benefits of victim lady by the employer for crediting the same in favor of the petitioner. Stop. Court is not. Now, stop. Mr. Cord, learned senior advocate representing High Court administration, has submitted that as per the recommendation dated 26th August 2025, complaint has already been lodged before the concerned police authority. However, concerned police authority stop. However, it is submitted on behalf of the petitioner that where is the bail order?
But page 257.
That the petitioner has obtained that the petitioner has obtained bail on 16th October 2025 from Chief Judicial Magistrate, Calcutta. Stop. Police authority shall be at leave to continue investigation based on criminal complaint lodged against the petitioner as per based on criminal complaint lodged against the petitioner as per the and charge sheet may also be filed. Stop. However, no further steps shall be taken after filing of charge sheet. In connection with the criminal proceeding till disposal of this writ petition. Next paragraph. Parties shall be at leave to file application in connection with the present writ petition for vacating or variation of the order passed by this court today, if situation so arises.
May I make one more prayer? We shall prepare the demand draft because, my lord, there was an interim order passed by the committee that, my lord, I should not come in contact with the victim lady. So, my lord, after preparing the draft, may we submit the draft in the office of the Registrar General, and the Registrar General be directed to hand it over to the victim lady.
আচ্ছা ওইখানে যে পেমেন্টটা বললাম না বাই 7 days, ওটা বাই ফর্টনাইট করে দাও, বাই ফর্টনাইট করে দাও 7 days-টা। Stop. Petitioner shall issue a demand draft in favor of the victim lady, and same shall be submitted before the Registrar General, High Court, Calcutta, by 7 days from date, and it is to be handed over by the Registrar General, by the Registrar General to the victim lady. 7 days. 7 days.
7 days.
You will issue the demand draft shall be issued in favor of the victim lady by 7 days. It will be handed over. It will be submitted before the Registrar General. And Registrar General shall hand it over to the.
Defer correct name, particulars, spellings, but it can be unofficially provided to us.
No, it is there already.
Complaint
complaint
ওটা আমি নিয়েছি। has used the word charge sheet. My lord, could it be police report instead of charge sheet? Because other, but it will be a one-way traffic if it falls from your lordship. My lord, police will give charge sheet then. Could it be police report? That. But if your lordship is using the word charge sheet, then my lord, the police authorities, my lord, will go for a charge sheet. But could it, if the term could be police report?
But I have recorded an order that police shall be at liberty to
file charge sheet.
দেখেছো কি এসব রেলিভেন্ট জায়গাটা কি বলছে?
But if it comes from your my lord,
ওই চার্জশিটের ফাইলিং এর জায়গাটা পড়ো তো। No, police report may also.
Yes.
Maybe in the form of charge sheet or report.
Yes.
Let it be. But if it is charge sheet, then
in that case, my lord, I will be prejudiced.
Investigating agency will be influenced to file a charge sheet.
No, my lord. Let it be recorded that if, my lord, it appears a charge sheet or
So this police report also
includes a charge sheet. It could be a final report or a charge sheet.
So this is the exact term used under 173.
170. Madam, grateful.
Old 173.
Old 173.
my lord, difficulty is that
Yes, rightly pointed. Police report code.
Grateful.
If it is adverse to the interest of the petitioner, if materials are found against the petitioner, then it will be in the form of charge sheet.
let it be recorded, my lord. My lord, otherwise, my lord, what will happen, my lord? It will prejudice the police officer.
My lord, that is a neutral position.
That is not the purport of 173.
My lord, that's
No.
Lordship knows that, my lord, but police authority, my lord, I doubt, my lord, how much knowledge they have.
ওটা police report করো।
Grateful.
Item number 10 for the petitioners, my lord. It's out of the same recommendation. The rest 2 persons are before lordship. If your lordship stands to page 255, the recommendation portion. Now they are in service.
Preliminary objection, my lord, because these 2 employees are in service. They have not retired, so they have a alternative forum, my lord, to prefer appeal from the recommendation.
It's an appellable order.
From the recommendation, my lord, I believe.
Where is the provision relating to appeal, Mr. Banerjee? Chatterjee.
Section 18 of the Act.
1940. Appellate authority আগে হচ্ছে
2013 Act.
My lord.
Is there any appeal provisions in the service rules?
In the service rules, my lord, but I've been told that there is a appellate forum, my lord, from the recommendation.
Tell me which forum.
Service rule against the recommendation, there is no appeal forum. But against punishment,
Section 18 says that non-implementation may prefer an appeal to the court or tribunal. To the court or tribunal in accordance with the provisions of the service rules.
is
Applicable to the said person where or where no such service rules exist. Suppose there is no appeal provision relating to the service of the employee exists, then without prejudice to the provisions contained in the law for timing in force, the person agreed may prefer an appeal in such manner as may be prescribed. So tell me that where is the appeal is to be preferred.
no, the appeal to the court or tribunal. This tribunal is no more there.
Well, very well, come back on Monday. Tuesday.
One.
Apply your mind, come
one
back on
thing, my lord, we are
Tuesday,
facing
not
out,
today.
there is a direction.
It is adjourned till Tuesday.
But after
Monday will be the original combined list day.
after filing of this writ petition, my lord,
Think over it, come back.
after
Please,
filing
next matter,
on
call the
20
next matter.
my lord, instead of Tuesday, my lord, could it be a Wednesday? But I would not.
Wednesday, your writ petition, Wednesday, very well.
Good.
Come back on notice. And you also obtain instruction. What would be the appellate authority?
But
Who would be the appellate authority?
yes. There is a
One thing, my lord, kindly, if your lordships allow me.
Next matter, next matter,
25th,
next
my lord,
matter.
I have
Father,
asked to
please.
deposit
Yes.
the money after filing of this writ petition.
Yes.
After filing of this writ petition, 25th, my lord, I have been served with the notice that I was directed to pay 10,000 to the aggrieved woman. That is to be deducted from my salary this month. That I have been served on 25th itself.
Paid. It can be recovered from.
So instead of my lord recovery, kindly allow me to pay. Kindly allow me to pay subject to final outcome of this, my lord. Kindly make this order.
Next matter. Mr. Kaur, please come back on Wednesday.
So kindly make this order so,
Yes.
so that my lord, I can.
No order I am passing today.
This petition should be dismissed.
Please call the next matter.
item number 11.
My lord, item number 11, I'm appearing for the respondents, Eastern Coalfields Limited, my lord. My lord,
But I am for the
I have
respondent.
the
I am for the respondent numbers 2 to the 6, the ECL.
my lord, item number 11, I have been instructed to appear in this matter, my lord.
This is my appeal.
Who is appearing for the respondent?
My lord, I am appearing for the respondent ECL, my lord. This morning I have been
You are also
instructed.
appearing for ECL.
Yes, sir. There should not be any conflict. My instruction is today is that
then sort it out and come back.
The only thing I have not received any. I don't think they have also received Wakalatnama and instruction from the
No, no.
department. So kindly
My
keep
lord,
your
I
question-
have got the instructions from the department HOD legal this morning
What is
that I need to
happening?
appear.
Kindly keep it on Wednesday or Tuesday according to Lordship's convenience, because Monday is monthly day and by that time it will be dissolved. And there is no urgency because it's been 13 years that they applied for an employment.
Applied for?
An employment in the death scheme.
Well, I was minor at the time of death of my father.
So it's been
After
13.
attaining the age of 18 years, I made an application.
Will obtain instruction.
Yes, that is the reason. Well, Tuesday or Wednesday, this will be resolved. Anyone
Not
or-
affidavit service be kept with the item.
No, take it back. Take it back, file it on the next day. You obtain instruction.
Yes.
My lord, my lord.
Item number 12.
My lord, I'm for the petitioner, my lord. Service is incomplete, my lord. Service is incomplete, my lord.
Then why you have stated that the matter is to be moved on 27 November 2025?
It is delayed, my lord, extremely sorry.
This court follows the procedure that as per the presentation form matter will come, but you have to ensure that the service is complete. You are representing
The Union of India, my lord. I am seeking time for my lord only for instruction, my lord.
only Union of India is party.
My lord. CRPF is the party, my lord.
So you are representing Union of India. Then they are representing. No issue. What is the matter about appointment? Constable GP.
No.
Departmental proceeding, my lord.
Departmental proceeding.
And he has challenged one advisory note, my lord, that has not been annexed. The annexure P1 mentioned is that
Obtain instruction.
my lord.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Learned advocate representing the respondents has learned advocate representing Union of India has paid for accommodation to obtain instructions. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 4th December.
Item number 13.
My lord, on the last occasion, this was adjourned. The matter your lordship is looking into is Iran Sheikh. Now, my lord, where the dispute occurred was they all moved writ application in a group. So, my lord, the cause title has shown somebody's name, but I have obtained the cause title. The cause title, his name is there. That subject to correction by my learned senior friend. Otherwise, my lord, the
Cost titles different name is there.
my lord, this is the second.
13. In the cost list, it has not been properly printed.
No, my lord. No, last occasion there was a dispute as to whether this petitioner has approached this honorable court on an earlier occasion. Now, my lord, from the order by which he was called for the interview, it was found that, my lord, only the writ petition number was there. Now, my lord, I ascertained that they have moved the writ petition on the earlier occasion.
Who has moved?
This petitioner, along with other petitioners. So that's why the person, my lord, whose name was appearing at the top, his name was appearing. So that's why this
And
petitioner's
others.
name was not appearing.
In the call letter.
Yes, with call letter, he was only intimated that you come for the measurement. That your lordship will find.
Who? The petitioner number 1 was directed to appear for measurement.
No, my lord, may I submit? Your lordship, my lord, on the last occasion, it was.
Last occasion, no order was passed.
No, it was adjourned because I was directed to ascertain that what was the correct position, whether this writ petition on the earlier occasion has approached this honorable court. Because my submission was that these writ petitioners approached this honorable court on an earlier occasion, wherein directions were given for remeasurement. The department called them, remeasurement was done. Now he has crossed the hurdle of 169.5. Now rounding off is applicable. Only I was to ascertain whether he has approached on the earlier occasion. Because
you approached earlier occasion, but on a different cause of action.
Yes.
Say so.
Yes.
It was pre-measurement stage.
Yes.
So that you can be provided opportunity to be measured by the respondent authorities in physical standard test.
Absolutely.
Yes.
I'm grateful, madam.
Lordship,
Yes.
yes, Lordship, I have obtained. Lordship,
169.6.
Yes, Lordship, I have obtained instructions. These medical, Lordship, the first is the physical standard test. Now, as in the advertisement, the physical standard test says 170. Now, this 170 is it's the starting point, and this is not the medical examination. That clarification I've just received now. In fact, an official clarification has also been issued. Now, that is not the medical examination. So the first hurdle has to be, as in the advertisement, 170 is the requirement. Those who are 170 and above, they are to enter into the next arena of medical examination, where the guide.
Medical examination.
Yes, these tests are not by the medical people. The first measurement, the scale. No. Then when they enter into the medical examination, Lordship, that is where when they come to the calculation of the BMI, whether he's overweight, taking his height. That in that case, that is where the rounding up, if there is anything, any shortfall that comes for the detailed measurement there by the medical people, then the question of rounding off or that thing
No,
comes
but
in.
if on the ground of 169.6, petitioner is not permitted to participate in the medical test, then where is the use of this relaxation as provided under
This
2D?
relaxation is not for that relaxation is for the BMI, and then
no, that is not the part of 2D.
No, Lordship will.
I'm not agreeing with your
Lordship, that is in my
submission.
instruction.
Sorry.
Because that is for medical examination.
Only, my lord,
Therefore,
my lord, allow me. This has been on a side. There has
Yes,
been a line. I'm sorry.
That is not the part of 2D.
and Lordship, we have there has
It
been
clearly says that borderline cases of overweight, BMI should also be considered to arrive at conclusion and variation of 5 kg plus minus from minimum to maximum limit may be accepted. So far overweight is concerned,
Lordship,
provision ends, please.
Yes.
Provision ends here. Full stop. Similarly, it's a different issue. Similarly, while measuring the height fraction of centimeter less than 0.5 will be ignored, and 0.5 centimeter and more will be rounded off to the next higher centimeter.
Could I just put it in one thing, Lordship? The BMI is the body mass index.
That is in connection with overweight.
No,
it has
that
nothing
is-
to do. Yes, BMI, in order to consider the BMI, weight is one of the relevant factors. That is
weight and
that
height,
is relevant
that is the ratio.
if it is found that the candidate is overweight.
Lordship, the obesity is calculated with BMI, height and weight, the ratio. That
correct.
That is the
Correct.
And
That is
my humble submission.
That
is, Lordship,
provision, Miss Alam, comes to an end before similarly.
No, Lordship,
So that's why it should not be read in such a fashion that this relaxation which has been granted in favor of the candidates who were measured the height in between 169.5 and 169.9, that it is related to BMI.
What I'm trying to say is the first stage of examinations.
I have already
Lordship,
passed
that
order.
I understand.
Sorry, you test my order before the appellate order.
Lordship, that is the first.
Before the higher order.
Lordship.
No, sorry. That is, it is apparently clear.
Lordship, that
BMI, so far BMI is concerned, you are absolutely correct. It is calculated based on weight of the candidate and height of the candidate. Please listen to this quote. This is not a place to hold conference.
No.
BMI is calculated based on height and weight of the candidate. You are absolutely correct. To that extent, height is relevant factor. But that provision ends before the sentence starts with similarly. Similarly, full stop. Similarly, while measuring height fraction of centimeter less than 0.5 will be ignored, and 0.5 centimeter and more will be rounded up to the next answer.
My humble submission is the first stage is not with medical officers. The guidelines come in when the medical examination starts, and then
BMI is to be
at that point, not
BMI is to be considered. But at the threshold,
it's only the height.
Physical standard test. If a candidate's height is measured 169.7, he will be debarred from appearing in the medical test on the ground of height. Then where is the question of granting relaxation, Miss Alam?
Lordship, that is when on a detailed test,
if you submit that those candidates who are coming within the parameters of 179.5 to 179.9, they will be permitted to participate in medical examination, then I can understand.
Anyway,
then I can understand that there is a logic behind it, or there is a rationale. But if on the ground of height, which is less than 0.5 centimeter, a petitioner is thrown out, a candidate is thrown out, then where is the question of further consideration of the petitioner for the purpose of extending the benefit of this relaxation which has been contemplated under
this
2D?
happens when a person is not thrown out at the threshold, when he faces that.
Then you will allow them to participate in the medical test?
Lordship, your Lordship's
if it is your submission that that stage has not reached, it is to be considered at a time of medical test, then allow them to participate in the medical test.
Lordship, this is the threshold screening. That is
at the threshold, they will be thrown out. So there is a specific provision in 2D relating to relaxation.
Lordship, my humble submission, your Lordships are fast in order, Lordship. I'm not, but my humble submission, this is at a later
Think over it and come back. Tuesday. And also take instruction, Miss Alam, whether those candidates whose height is measured as 169.5 to 169.9 would be permitted to participate in the medical test or not.
I should.
Your Lordship, kindly
come back.
Lordship,
because he clearly says the medical officer will not conduct.
Is it Tuesday 2nd? Lordship.
Tuesday 2nd. You have difficulty?
Yes, on Tuesday.
Matter is heard in presence of the learned advocates representing the petitioner and Union of India. Stop. Matter relates to relaxation of height. Matter relates to relaxation of height, whether to be extended in favor of the petitioner, as the petitioner was measured, as the height of the petitioner was measured 169.6. Stop. Next paragraph, next paragraph. Learned advocate representing the respondent authority is directed to obtain further instruction whether the petitioner who was measured 169.6 centimeter, ওটা আগেরটাও সেন্টিমিটার করে দিই, সেন্টেন্সটা কি বলছিলাম? Now, whose height was measured 169, whose height was measured 169.6 centimeter will be permitted to participate in the medical test or not. Next paragraph. List the matter under the same heading for further consideration on Wednesday next, comma, 3rd December.
Right. Deeply attached.
Otherwise, this relaxation provision will become obvious.
My lord, it has been written that only the PST
That is
board
my
will-
instructions which I have got today. Lordship.
issues has
Think
been
over it.
decided.
Otherwise,
Since I am passing similar orders based on the first judgment, I have
that is why I brought it to your
Whereas,
notice, Lordship.
court is open to
No, that is why I
court is
brought
open
it
to
to your
accept
notice,
the
Lordship.
submissions
Yes.
which are to be advanced on behalf of the respondents as well as petitioner. You also apply your mind and obtain instruction. Come.
And the circular clearly states.
Next matter.
The same.
Item number 14.
Reserve your energy for the next date. Yes, same thing.
Lordship, 14 is also the
Yes,
same.
same thing, my lord.
Same.
Where is your height measurement document? Which page, Mr. Shandal?
18.
18.
Yes. Look, volume Didi, Chadon, please. A minute. Page 23. I'm sorry, my lord. Didi, please. 169.7, the remeasurement. Page 23, my lord.
Very well. Wednesday.
Wednesday.
I'm not passing order in this.
No, Lordship.
Adjourn till Wednesday. 3rd December.
Item number 15.
My lord, same page 22, the remeasurement is appearing.
This is
169.
15. 15.
22.
Page
22. Remeasurement. 169.6.
এখন করিস না, এখন করিস না।
Wednesday.
Item number 16.
16, we are not in.
No, I am for the petitioner.
For the respondent.
No, I am for the petitioner. The petitioner was appointed as a Safai Karmachari as Safai Karmachari staff under Central Bank of India in Ranaghat branch. And that was a temporary post. I worked there for about 55 days. But thereafter, my service was terminated. Thereafter, on the basis of an application, on the basis of a notification and a circular of the bank, I applied for permanent post, but that was post by mistake. I made myself as a general candidate, but I am a OBC candidate. But my application was, I was not successful. That is why I came before this honorable court. And my lord, Mr. Justice Dipankar Datta, as his lordship was pleased to dismiss the writ petition. Against that,
Dismiss the writ petition.
my lord. Against that, I filed a writ, and order was
Against that, you filed an appeal.
Appeal. And page 16, your lordship kindly come to the appellate court's order. No, 16 is the single bench order, and division bench order is page 19. Page 19.
However, in any.
Just a minute. Yes.
No, actually, the order is that.
What is your present age?
Any case, any vacancy.
What is your present age?
No, if any notification is made for VC candidate. No, that order was passed February 2014. Today we are in the year 2025. No, they have not yet notified any vacancy, though they have appointed many persons that I have stated.
What can be done? Court cannot direct it because the division bench, honorable division bench has held that in case of any vacancy is notified.
Yes.
Not beyond. Now, what is the prayer made in this petition?
If you
For notification of vacancy, for notifying vacancy.
If your lordship kindly come, I made several RTA applications to know the position. One order, if your lordship kindly come to page 25.
So you have prayed for notifying vacancy.
Yes.
That depends upon the decision of the bench.
Page 25. If your lordship kindly come to page 25, a second appeal on the basis of my RTI application. Please supply the list of sex, caste, and branch of those who had been appointed and dismissed from service within 31/3/2018 for the post of Safai Karmachari cum Substaff as per circular dated 2012. If you will come to page 26, last paragraph, 5.2. However, the appellant's candidature was not found suitable, hence he was not selected for the service. How they have come to this conclusion? I never applied after the circular was last. However, last
Second appeal was preferred. What was the information you sought for?
That has been written in page 25, top first paragraph. Please supply the list of.
Yes.
Look, thereafter your lordship can come to paragraph 22.
Paragraph?
Paragraph of my writ petition, which page 9, para 22.
Yes, what is stated there?
Several persons have been appointed without any circular. Several persons have been
May be appointed on a temporary basis for which vacancy notification is not required. Issue. Affidavit of service file or affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner was working as
was a casual staff. Casual Safai Karmachari.
petitioner was working as Safai Karmachari cum sub staff of
well, let there be a direction for affidavit so that they can disclose the
of
vacancy.
Central Bank of India Ranaghat Bank branch. Stop. A proceeding was initiated against the petitioner and petitioner was removed from service.
No. As it was a temporary post, it was.
A petitioner was removed from service.
No, he was not even removed. Casual for a few number of days he worked.
More than 50 days.
He says 50, it was never 50 according to us. Temporary basis.
That certificate is with me.
Before, he had worked on temporary basis, he says for more than 50 days. But
No.
there was no removal from service. He was never in service.
কি বললাম না কেটে দাও it is stop however petition service of the petitioner as Safai Karmachari hyphen cum substaff was discontinued as it is submitted on behalf of the bank authority. That petitioner was appointed on casual basis. Stop. Next paragraph. Based on an advertisement issued subsequently, petitioner offered his candidature by submitting application on 15 September 2012. Stop. However, petitioner applied under general category, not as other backward class category. Stop. Based on call letter dated 7th February 2013, petitioner participated in the interview on 2nd March 2013, but he was not selected. No, he did not participate. না ঠিক আছে he did attend. On publication of the result of such selection process, petitioner found that he was not selected. Stop. Result was published on 16 March 2013. Stop. Thereafter, petitioner on 28 March 2013 made a representation before the concerned authority of the bank, stating that he was required to be considered as OBC candidate, not general category. Though inadvertently application was made by the petitioner declaring himself as general category candidate. Stop. As the prayer of the petitioner to treat him as OBC candidate was not accepted by the bank authority, which prompted the petitioner to file a writ petition being WPA 31776 of 2013, which was dismissed by a coordinate bench. Video order dated 13 November 2013. Stop. An intra-court appeal was preferred, being MAT 58 of 2014, questioning order dated 13 November 2013, which was disposed of by the Honorable Division Bench by order dated 28 February 2014. 28 February 2014. Stop. In the said order dated 28 February 2014, it was directed by the Honorable Division Bench. Now, it was observed by the Honorable Division Bench that in case of any vacancy, is notified under for recruitment of candidate under OBC category, it would be open to the appellant / petitioner to apply in that category and to stake his claim in accordance with law. Stop. Next paragraph. Based on such observation made by the Honorable Division Bench, in the order dated 28 February 2014, present writ petition is instituted, seeking a mandamus, thereby directing the bank authority to notify vacancy, which would permit the petitioner to offer his candidature under OBC category. Next paragraph. It is right that decision to initiate a selection process for filling up vacancy is within the domain of employers within bracket bank authority, and for that writ court ought not issue mandamus. Stop. Next paragraph. Considering the prayer couched in this writ petition, seeking a direction upon the bank authority to initiate a selection process by issuing a notification for considering petitioner's candidature as OBC, comma, court is not inclined to pass any direction. Stop. Writ petition stands dismissed. Urgent xerox.
But the appeal court's order will remain. Kindly make it clear. Otherwise, it may be.
Is there any confusion?
No,
the appeal court order will be
for me.
order passed today.
No, this is a subsequent order. That is
No,
why.
sorry, Mr. Mondal, that is not required. This is the order of the single bench, and that is the order of the Honorable Division Bench.
Well, affidavit of service may be filed in course of today. It is being approved. It is being.
File it. Other side is represented, no issue. Na, dorkar nahi, kete dao. File your affidavit of service.
Item number 17.
My lord, this is a matter. This is a matter wherein, my lord, the petitioner participated in
169.2. It was enhanced to.
Well, it was not enhanced. It is the first time, my lord, we are approaching your lordships, my lord.
So you are not entitled to get any relaxation.
My lord, we only pray before your lordship that, my lord, if you may be given an opportunity of remeasurement, because, my lord, we have already made some representations at page 22. My rejection is at page 15. and appeal not preferred.
So this representation be considered. Representative, since no appeal was preferred within time, now appellate authority is not present. Now perhaps CRPF is the appropriate authority to make to take measurement.
Where this court had directed them to appear for measurement.
Yes.
Those cases were considered pursuant to the order. Here he
Who is the appropriate authority to take measurement now? Because appeal time to prefer appeal is not there.
and he has not come before this court.
Yes. So therefore, who will take measurement? CRPF. Because CRPF is the nodal agency.
So that yes.
Have you made the CRPF party?
Yes, my lord.
Central Reserve Police Force.
Respondent number 5.
South Bengal Frontier BSF. 5 is at Delhi. Who is the authority here at Kolkata?
My lord, here, my lord, Inspector General Central.
Inspector General Central. Yes, sorry.
Faultless.
So let the 7 take steps based on the where is your representation? Where is your representation?
My lord, at page 22 and 23.
Issue.
Could this matter be kept with the other matters?
No, let the matter be disposed of today.
Yes. Those-
Issue.
As your lordship.
Yes.
As your lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD in Central Armed Police Forces within brackets CFPs. Stop. During physical standard test, height of the petitioner was measured 169.2 centimeter, which is below the requisite height, that is 170 centimeter. Stop. Though there was an appeal provision, same was not availed of by the petitioner at the material point of time. However, representations were made before the concerned respondent authorities for remeasurement of height of the petitioner. Next, it is submitted that remeasurement is yet to be taken. Next paragraph. Yes. Union of India is represented by learned advocate who has submitted that time to prefer appeal is over. Now remeasurement can be taken based on representation. Union of India is represented by learned advocate who has opposed this writ petition as time to file appeal is over, and at present appellate authority is not available. Next paragraph. Having considered the submissions made on behalf of the parties and taking note of the fact that a representation was made with a email letter dated 6 September 2025 before the concerned respondent authorities, petitioner needs to be remeasured. Petitioner's height needs to be remeasured by the concerned authority. Next paragraph. Accordingly, Inspector General Central Reserve Police Force, being respondent number 7, is directed to take measurement of height of the petitioner by fortnight from date, and the outcome of such remeasurement shall be communicated to the petitioner by 7 days thereafter. Next paragraph. Writ petition stands disposed of. It's a case of remeasurement. Yes, next.
Item number 18.
Well, at next item I am paying for adjournment.
Why?
Well, the mistakenly that has been communicated for copy servicing the copy in another date on 3rd. That's why
When you have stated?
Yes, I have stated in
27 November.
Yes, 27, but in the service note.
Service is not complete.
Service not, third, 20.
At the time of call, learned advocate representing the petitioner submits service of notice upon all the respondents is not complete. Next paragraph. The learned advocate for the petitioner is directed to complete service of notice by 7 days from date and file affidavit of service on the next date. List the matter under the same heading for further consideration on 8 December 2025.
Grateful.
Next.
Item number 19.
For the petitioner, my lord. My lord, since the respondents are not represented, I should indicate, my lord. 2, 3, 4, the department, my lord, relevant parties have been served. But with regards to Union of India, my lord, the service is yet to complete, my lord, out for delivery. They are not represented.
Who are the necessary parties?
My lord. 2, 3, 4, my lord, Director General of Meteorology, Deputy Director General of Meteorology, and Director in charge, my lord. I'm seeking enforcement of an office order, your lordship, and setting aside of the letter issued by them.
So all are to be represented by the Union of India. Is there any separate panel for meteorological department?
Not aware, my lord.
Issue. Learned advocate representing the petitioner prays for accommodation to complete service of notice upon all the respondents. Stop. Let notice be served upon all the respondents by 10 days from date and affidavit of service to be filed on the next date. Stop. List the matter under the same heading for further consideration. List the matter under the same heading for further consideration on 15 December 2025.
Grateful, my lord.
Item number 20.
I am for the petitioner, led by Mr. Ashish Kumar Chaudhary, my senior advocate. He is engaging before the learned.
Yes.
He is engaging before the learned court 8. Therefore, I am praying for not this week.
We will not today. Not today.
And wait.